Okay. After a long time, Mr. Dole. We'll pass orders. Don't worry. Your matter. Mention? No mention. Mention me. सब करेगा. आज केस करेगा सर. I'll pass orders. We'll pass orders. Oh, record some. Yes. Okay. Okay. Yes. Your colleague, two matters we had dismissed. I've gone through it. See, you are members of a discipline force. The matter that has come on record, how can we now interfere with that in exercise of powers under? Madam, you have got back the records of the earlier case? Hmm. Do you want to try your luck? Or you want to try it next week or the week thereafter? I can't take two views. I'll have to take only one view. Hmm. See, the problem here is that people are put there for security. They do their duty. There is no dispute here. After that, they leave, which is not the norm. You cannot all live together. Roster basis, I understand. Show me the charge here. Just charge. Come to article of charge number 2. Madam, that is the same thing here. Same issue. No. The earlier two cases here, the factors are different, but the issue is the same. Hmm. 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 Okay. Argue. I gave you an option. Now you argue. Hmm. No, you argue. You make your submissions. Make your submissions. Two options to you. I hear it or you take an adjournment because I have already, in the other case, disclosed my mind. If you want to take a try, fine. I have no objection. Next week. Okay. On the front. Four together, I don't feel like dismissing. On the prayer of the Learned Council for the parties, list this matter again on Tuesday, 4/6. You can rely. 4/6. 2, 3, huh? 2 and 3 both. You've got the records. Yeah, show me. When was the date of death? 11. And clear. Clear case. See the fall in the pressure level, blood pressure level. And there is no treatment provided. Madam, but there is a technicality. What to do with this? I can work a way out for you. I can work a way out for you. Do one thing, file an amended cost title. Put that boy's name represented by Srimati Junaki Mega. Why I am saying so? Because one of your prayers is to pay that compensation, if any, in the account of the minor. Change this cost title. Otherwise, I'll not accept this. Because a mother-in-law has got no role here. If you are representing a minor, fine. Represent it. Just change the cost title. Make a prayer to that effect. I'll allow you. And we'll have the matter on Wednesday. This is a case wherein something has to be done. It's your fault. Check that blood pressure level and show me if there is any treatment provided. Blood was replaced? No. Was it transfused with blood? No. Patient history is not required here. She is not anemic. She is anemic, but not that level. It's around 8.3. Pregnancy time, that is not very low. It's okay. When you notice that, you should have made appropriate arrangement. When you found that she is 8.3, at least you should have taken it up to 11 before making the operation. You have not done that. They don't know. They are laypersons. How will they know? See, it's 8.3. You know it. It's your record. Why have you not taken it up to 11? 11 is a very, one bottle, one infusion would have been, one unit would have taken it up to 11. And then if you had done the operation, maybe this problem would not have come. Normal delivery, but that she had bleeding after that. Madam, when? Monday you will change it? Miss K. Nada, Learned Counsel for the petitioner, and also Mr. Tagum, Learned Counsel, Standing Counsel, Health Department is present. Ms. Nada submits that the present petition has been so filed for and on behalf of her grandson. However, in the cost title, it has been shown that the writ petition has been filed by the mother-in-law and not as a guardian of the minor. So accordingly, she prays that she be given 3 days time to bring on record an amended cost title, to file an amended cost title in the matter. Prayer allowed. Petitioner is allowed to file an amended cost title in the matter. So list this matter again on Monday, 6/6/2023 2024 for further here for hearing. Full stop. The amended cost title be filed on by 4/6/2024. Right? Yes. What is the? Yes, madam. What did you get? Anything? See, I'm only on the question of your affidavit. If your affidavit says that that is illegal, everything should. Will not come in favor of the petition. Everything let it go. Right? When? Tuesday? So, Miss.
And your lordship, stay order is there, your lordship.
I know that.
So it's
but
pending,
we are
your
now
lordship.
on the final
The matter is
consideration.
pending.
If you say that the land allotted to him as well as to respond number 6 could not have been allotted, fine. We are saying will not do. You'll have to take an action on that.
Yes.
If it's forest land, both the lands will go. You can't have. Now, his allegation is that you are trying to build up a case that with regard to respond number 6, only 140 or 150 square meter will go. The rest will stay. His land is beyond that. If 140 only goes, how do you come in to interfere with his land allotment? It's all contiguous plots, right? Same area. Okay. As prayed, Miss Propounding learned government advocate
Yes, your lordship.
submits that she be given another 3 days time to receive instructions as to whether any follow-up action has been taken with regard to cancellation of the allotments made in favor of the petitioner as well as the respond number 6. 6 and 7. Full stop. Prayer accepted. List this matter again on 4/6/2024. You get that instruction?
Oblige, your lordship.
Yeah, bless. Thank you.
Yes, Mr. Das.
Appears to be working, but the very short point this issue is involved.
The matter went up to the division
Yeah,
bench.
I'll just place it in the aerial view, my lord. So I'll also make it more easier. My lord,
Always.
my lord, it's a case where my lord. Yes, my lord, there was certain plots of land belong to landowners. Now the
You are representing the landowner.
landowners by way of a power of attorney holder, by a power of attorney. Why I am using the word power of attorney? That one issue for a division bench. No doubt they have not taken any plea for the learned thing, and neither is a case of any pleaded case. But some at one point division bench they have raised. That's why I am raising this the power of attorney. The power of attorney represented, and this power of attorney is by way of an instrument. This is under section 3 of the Power of Attorney Act, which it can be given. Now, my lord, it belongs to the landowners. Some about 341 acres of hectares of land. Now, for the emergency purpose, the government of India, they wanted this land for defense purpose. Now, for that, all the process started. Process started from 2011 onwards. I'll show your lordship how the process started. 2011 onwards, up to 2017 before issuing a notification. and under section 40 before issuing a notification. So all the correspondence were done before defense assistant officer and the respective state government. And it was said, estimate also was prepared. No objection certificate was also issued by different departments. It was then joint survey was also done, and ultimately estimate was prepared. Estimate prepared about 125 crores they are entitled to get it. And this was placed before the defense estate officer in the year 2017, and that was forwarded. Now, in the meantime, the government issued 3 notifications in the present case under 41. 3 notification issue under 41.
No,
Which-
you continue with your
Yes,
policy.
41, the notification was issued. Now, after being notification issued, there are certain formalities under the Land Acquisition, the new Act 2013. Once a notification is being issued, under 21, you have to give a notice to the respective landowners that we want to take over this land possession. 20 under section
Can
21.
it be finished today?
But we'll start it if necessary.
But because I'm not
I
here
think-
next week.
No, that's why your lordship is there tomorrow also.
Tomorrow will not be.
No, I'll try to, it's very narrow campus the matter is. The lordship will kindly hear, it will not take much of the time. I can assure before your lordship. Then 41, under section 21, notice has to be given to the respective landowners. In this case, notice was given to the respective landowners, and accordingly, my lord, the land was taken. Possession was taken by the government. Possession was taken by the government. But the award which was estimated was never paid to us. That thereafter we approached this honorable court by filing way of a writ petition. The writ petition was, this is a very law point is involved here. Unlike 41, my lord will kindly take. Now, this matter was taken up by the learned single judge. Now, learned single judge said that this is under 41. So there is no question of any record. 40 bracket 1. 40 bracket 1. So if it is under 41, it is for emergency purpose, the land is being taken. So there is no question of award. My lord will kindly see section 40 for a moment. 41. Special power in case of urgency to acquire land in certain case. In cases of urgency, whenever the appropriate government so direct the collector, though no such award has been made, may on the expiry of 30 days from the publication notice mentioned in section 21, take possession of any land needed for a public purpose, and such land shall thereupon vest absolutely in the government free from all.
40 sub-rule 3 says that 80% of the men.
This is, my lord, this is what I was not in this case, very frankly, my lord. Later on I came. So third time the matter came up before the learned single judge. When
Not
it
the
was
same matter, not
yes,
disposed of.
no, it was remanded back by before the division bench. The learned single judge, first time it was moved before learned single judge. Learned single heard the matter and said that where is a question of record? It's a case of 41. If it is a 41, because never it was placed 43. I pointed out before the court is a 43 is once the particular you have decided to take this land for an emergency purpose, for defense purpose under 41, there is irrespective, there may not be any award in this case. No notice, because your lordship knows parameter clause earlier was 4, now it is 11. So apart from 41, if you want to acquire land for public purposes, then the question of notice comes. Then the question of award comes. All this will come. But this is a special case under 40. So there is no question of award. So now the intention of the legislature to put this section 43, my lord will kindly see why they, before taking possession of any land, 40 kindly see 43, my lord. But before taking possession of any land under subsection 1 or subsection 2, collector shall tender payment of 80% of the company for such an estimated by him to the person interested entitled thereto. Why this particular word, my lord, will shall tender payment? Because what I felt, my lord, this was because the person, here the landowner get displaced. Because once you take you issue a notification, my lord, there is no question of any cultivation of that land. And the intention of the legislature under 80% you take before the possession is being handed over. So that there is a right to livelihood. That's the intention of legislature. But nevertheless, my lord, this 43 never came up before learned single judge, neither before division bench. Now, the learned single judge heard the matter, affidavit was exchanged by all the parties. Learned single judge said that no, where is the question of record on the basis of 41 has gone to the writ petition, prayer, affidavit filed by the state government, ultimately said that no, they are entitled to get the payment of 1 crore to 22 lakhs, but subject to that within a period, certain period was mentioned. I think 3 months time was given, that payment has to be made. Now, this traveled to the division bench by the Union of India. Now, before the Union of India, they have taken 2 points. They have taken 2 points. 1 point, for the first time they are taking, it is represented all these landowner by way of power of attorney holder. That point they can raise before the learned single judge, but is remanded back to the court. Number 2, if you see the wording of 41, kindly see the wording of 41 once again. In case of urgency, whenever the appropriate government so directs, who is the appropriate government, my lord? The central government. Kindly see appropriate government. If you see the definition of appropriate government, kindly see the definition of appropriate government. Appropriate government is E, definition 3E.
In relation to acquisition
In relation
of
to
land,
actual
it is
land,
state government here.
yes, provide respect of so and so of an area, so and so.
It's
So
a state
now,
government.
yes, now what it says, my lord, their whole contention before the division bench was that, where is the sanction? Where is the sanction? How the government, without my concurrence, has issued this notification under 41?
Government here would be the state government.
That's what. But whatever may be, that was what they projected before the learned division bench. Learned division bench said, what we'll do?
Their projection was the Union of
India. Union of India projection. The state is not. The Union of India went before the division bench. Their projection is that they have gone ahead, notification issued, but where is our sanction? There is no sanction which was given by the central
Do
government.
they say that they don't want that land?
Now, 2018, they're saying that we don't want that land. We want some other land. 2018. After the notification issued, all the formalities has been done. Position taken by
Position taken by whom?
by
State or by the
by the state. Why not? The issue here is that once this is parameter is 17.1 of the old act. 17.3 is the compensation 80% for taking the possession. It's a parameter is 41 and here is 43, 80%.
Where is the initial notification?
Yes. Let's see the initial notification. My lord will kindly see the notification issued is at page 99. See 99. There are two notifications. One is 41 and one is Balipara. Kindly see. Issued under section 41 of the right to fair compensation, so and so, reappeal so and so. Where is the power and function of so and so execute discharge? Appears Arunachal likely to be needed, so and so. Indian Army, namely acquisition of land.
What is this wording likely to be needed?
For which one, man?
The second paragraph.
Where is the power and function of authority?
No. Whereas it appears to the
Appear
government that the land is likely to be needed.
At the localities or locally more fully described in the schedule below for Indian Army, namely acquisition of land for army at so and so, for establishing a defense post at the expense of the government.
So has the Union of India shown or the state shown that this notification with this stipulation was so made in pursuance to some communication from
Yes, I will
they
do
have-
it. Yes, there are communication. Where is appears to governor, land is needed in urgent for establishing a defense outpost. You can only see my lord. Whereas it appears to the governor that land is needed in urgent for establishing a defense outpost to meet up the requirement of Indian Army as Anjar districts. Therefore, this notification under 41. So, my lord, here we calculated page 100, it becomes 130 acres. I just calculated. 130 acres. The total is 341. See at page 102. 102, another notification issue. 41 is 20.27. Lordship got it? 41,
And in page 99, it would be
99,
total
102.
102.
99, kindly note down, is a one notification. Second notification is at page 102.
20.
Lordship got it? Now kindly turn to page 105. This is 38 acres, but under the Balipara Act. 10 of the Balipara Act. If your lordships looks into, in state of Arunachal Pradesh, even new act of 2013 came into force, my lord. Today also, the state government are issuing this notification sometime on 10 of the Balipara Act. But whatever estimate compensation will be under the new act of 2013. There is a notification of the government also.
I've seen it sometimes.
Your lordship has seen. So now, kindly see at page 116. See 116.
Stop activities.
Top activities. Now, 116 to 119.
Mr. Das, before you proceed further,
I'm
say
sorry.
in a situation, just
Yeah.
for my understanding, there is a parcel of land which is contemplated to be necessity of a public purpose, and that was taken over.
Yes.
But subsequently, that public purpose did not occasion. Now, what would be the way, how the parcel of land would be dealt with?
Now there are two situations here. If it is
We
not-
have Tata Motors.
if it is
We have
yes,
Tata Motors in West Bengal.
whether can be vested, divested. There are two issues here. Now, if it is a case under 40, which is parameter, there is once you have taken possession, there is no question of reverting it back. There are judgments of the Supreme Court. I'll show your lordship. But if it is unlike 41, then normal. Then you can.
You have a right to
Right.
get back that.
Right. Now, even if you have a right to get back and you are holding this particular land position, then compensation they have to pay.
Okay.
Even then.
You say you have filed this application on the basis of a power of attorney.
Yes.
Who are the persons who would be affected?
The
The
landowners.
landowners. Where are they?
I'll show you.
There is a list of those people.
Yes. I have given. They have given the power of attorney. That is instrument.
No, I'm not on the power of attorney. In the writ petition,
Yes.
where is the list of persons or
Yes.
landowners
Yes.
whose land have been
Yes.
taken over?
NHO 1 first see, Mr.
That
Thank
is
you,
the irrevocable power of.
Power of attorney.
I got it.
He has got it. Not one. 28. Kindly see. Paragraph 8. Page 8, para 2 of the writ petition. And that is an instrument. It's a register.
Why was these people not
They,
in a position to at least sign a vakalatnama when
they
sign a
are far this particular.
No,
Your
signing a
lordship knows it.
vakalatnama
Signing
Signing a
it's
vakalatnama
a huge, my lord.
would have been a
task.
easier way.
No, I fully understand.
Why that
Why
they were
that-
not?
No, that my lord, today also, if your lordship is
Because
not a
it's
case,
an individual
no,
right.
it is not a case.
See,
no,
it's an individual
no,
right.
maybe. My lord, what is the event today? If the award is being passed and the money doesn't go direct to the power of attorney holders, it will go direct to their
Why
account.
should we, when it's each parcel of land, each landowner having an individual right, not being before us?
But they normally also, I have seen, I can produce, there are other writ petition also. I have seen some of the power of attorney holder represents, duly representing. And I'll tell you, lordship.
Mr. Das,
No, I'll tell you,
I
lordship.
can understand
what is
I can understand one situation wherein the affidavit has been filed.
I will say, show you.
No,
Kindly see.
just
No,
clarification.
I have understood your lordship point. Why this particular landowner before the court?
He can be authorized
And
to
what-
sign the affidavit.
Now, what is the powers? Once it is authorized, then as if he has come to court and he is acting on behalf. I'll show. Kindly see the Power of Attorney Act, my lord. See the Power of Attorney Act. See the Power of Attorney Act, my lord. That part also I have seen, my lord. I know that a question will come across to me. See the Power of Attorney Act. See, kindly see, my lord, 2. See 2. Kindly see 2.
Section 2.
Section 2. So, see section 2. Lordship got it? Section 2. Execution under power of attorney. Donee of a power of attorney may, if he thinks fit, execute or do any instrument or thing in and with his own name and signature and his own seal, where sealing is required by the authority donor of the power. Every instrument and thing so executed and done shall be as effectual in law as if it had been executed or done by the donee of the power in the name and with the signature and seal of the donee thereof. Now, to this, I'll show one
Now, show
judgment.
me something.
Yes.
This I know. If you have, by this power of attorney, you can execute any instrument.
Yes.
Transfer of the land.
Yes.
You can do
Yes.
whatever act is there in terms of the authority given to you.
Yeah.
But for filing a case, why is this procedure resorted to?
These are,
Because Mr. Das, the only thing that is required for filing a case is a wakalatnama, right? Along with an affidavit. Facts will come. Affidavit, our High Court rules provide that there is a paragraph. When there is more than one, it has to be shown that they have been authorized. They have authorized a particular petitioner to execute that or swear that. That much only. Now, where does this concept
no, your
of power of
logic, no,
attorney-
no, no.
Tomorrow, a teacher in the school
my,
will come up
no, no,
with
your,
school.
how it authorized, power of attorney has given them how
I've
it
seen
is.
it. I've seen it.
See, kindly
It's all
see.
vague.
To number
It's
2,
all vague.
kindly.
It's not for the sole purpose of filing this case.
No, the kindly see.
It's not.
No,
It's
that
there for
authority
many other
is
reasons.
empowered to place my grievance before the competent authority concerned and engage
Fine.
a lawyer for
Yeah,
filing any
so-
suit. So other professional connection efforts a land matter. Now you see judgment of the Supreme Court, how it has been dealt. This was a question which was raised.
What is the objection with regard to this by the, who has raised this objection?
No, that's the reason. For the first time, they came to the
What
court.
did the High Court's
At that
division?
point, division bench said that will be decided if necessary. No, my lord.
No.
Normally,
just trying to-
my tenure, I know that in between mid of you cannot come and that this is not maintainable.
No.
At the very first instance, you have to come. This is not maintainable.
Okay.
End of the
But
day, you come
Where is that
after.
order of the division?
Yes.
To that extent.
Kindly see order of the division bench.
Order dated,
Order is at.
Nine-
Order is
4-1.
9/12/2021.
no, 4.
Date of judgment is 4/1/2022. Now, if you see, may I read the entire or just
No.
the important? 5, para 5. Para 5 kindly see. The learned counsel for the appellant submits no proposal issued by the appropriate government or central government. There can be no acquisition proceeding under section 40 of the Act and direction of learned single judge to Army authority as per number 7 to deposit the amount payable before the additional deputy commissioner to whom the acquisition proceeding was started to have been conducted is a finding not based on records and therefore the same needs to be interpreted with said. So and so, as is the power of attorney holder of land vehemently oppose the contents of learned counsel appellant. By referring to pleading, there were several correspondence between the army authority and the government of Arunachal regarding the said acquisition proceeding. Therefore, it is too late in a day to contend there was no sanction to central government acquisition proceeding. Learned counsel for landowners submit the learned single judge a duly examined record and thereafter has passed the order which is impugned the present appeal. Therefore, the same need no interference at all. Vidhi Goswami learned so and so. Insofar as state government is concerned, notification issued for acquisition of land and which could not have been issued unilaterally unless the army authority have sought for some acquisition. He refers to notification under section 40 of the Act, which is enclosed and so and so. Now this is the 8. We have heard the learned party and we have also the pleading on record. Carefully peruse the provision of right to fair so and so. Insofar as central government is concerned, appropriate government would mean the central government. Section 11 of the Act prescribes for publication of preliminary notification. There is no dispute at the bar that the acquisition proceeding was initiated under section 40 of the Act. which empowers approving to acquire the land in case of urgency. Although it has been submitted notification under Section 40 issued by Secretary, so and so, however, the State Council have not been able to furnish record any such requisition received from the central government under Section 40 of the urgent acquisition of land. 2013 Act is a complete code. Now this is what says, my lord, 9. Since there are several disputes, question of fact will arise as regard the acquisition proceeding and the compensation required to be deposited. According authority as well as with regard to compensation amount thereafter required to be released to the affected landowners. Original writ petition would not entertain any such proceeding involving disputed question of facts, especially in the statutory remedies being available to such aggrieved parties under Act of 2013. However, upon perusal of the impugn order passed by learned single judge, we find learned single judge has perused and had thereafter being satisfied had disposed of writ petition directing the assessed amount to be deposited within a period of 3 months from the date of the order. Although records of the case were duly perused, learned single judge, however, declined to enter into merit of the dispute, disposed of writ petition direction to deposit the complaint amount within a period specified. Although in the impugn order it reflected, records have been duly perused by the learned single judge. However, no reference in respect to any sanction for acquisition proceeding issued by Ministry of Defence, central government has made be available in the records have been referred to the learned single judge. Under such circumstances, since the learned single judge, after perusal of the records of case, passed the impugn order and has such direction to respond of 125, namely the appellant herein, we deem it appropriate to remand the matter back to a learned single judge for a fresh decision on a dispute between the parties. The question, now kindly see, the question of whether a power of attorney holder can maintain a writ petition on behalf of actual landowner may also be an issue. May also be an issue the learned single judge may decide to deal with rehearing the matter. May itself, my lord, that's why I am saying.
But Mr. Das,
Yes.
the division bench found favor with the contentions of the Union of India on 2 grounds. That last thing is just an addition.
Yeah, yes.
Forget it. We'll consider that.
Hmm.
But the main ground which I think found favor with the division bench was the issue that the Union of India had never.
No sanction.
Sanction cannot be there. It should be a requisition.
Hmm.
We'll read it as a requisition.
Yes.
Although the order in one place it has been said as sanction, we'll read it as a requisition. There was no requisition from the Union of India, and accordingly, they are not liable for the consequential actions taken by the state. And the court said, has found that 51, you can take back the land. Basically on this, and then finally, before ending, the court said that the issue of an attorney holder approaching this court on behalf of a determinable number of petitioners, whether would be permissible. So these are the 3 issues now before me, right? Now, first, as that last issue we take up, attorney holder, then we will proceed. Second issue would be the stand of the government by and between them as to why this notification under 11 was issued. Oh, sorry, 41 was issued. Second aspect, that for that we'll have to hear the state government and the central government. And the third aspect would be if these two, a decision is arrived at, the third would, compensation payment will be automatically decided.
No, if your lordship decides, number 1 issue is regard whether the power of attorney holder can file this writ petition on behalf.
That would be the issue which will take me into the matter on merits.
No, then your lordship, see, my lord, if your lordship decides on and saying that this writ petition is not maintained, where is gone?
No, I'm not on that. I'm not on that because see, Mr. Das, I'm bound by this order.
No, I'm saying that's why I told your lordship. I told frankly these are the points. First, when I addressed it, that was the first point.
You told me the first
point.
Yes.
That writ petition they have taken for the first time. Because now your lordship, with great respect, your lordship is bound to take that issue because there is a direction passed. Now, neither I cannot avoid, your lordship cannot avoid. That you have, lordship has to take that point on maintainability. But this my argument before lordship is, your lordship is worried about this, all the landowners are not before this court.
I'll come to
this
that.
Is.
I'll come to
maybe.
that.
But you say, I have got an answer to it. I have also an answer to it.
Yes,
I know what's behind the back of the mind that these are the landowners. We don't know this power of attorney holder hasn't come. The land belongs to them. Why they have not come? Now, this end of the day, wherever,
Mr. Das, I
suppose,
understand your submission. Your submission last would be that the final beneficiary to whom the payment would go if come, it would be not to this man, but to
so
the.
how, my lord, your
So you
lordship
say
wanted
that
to
there is enough safeguards here. So
safeguard.
that,
So
but I
for
want to
that
hear them.
purpose,
I want to hear them why this issue was taken up without a pleading being available in this
correct.
repetition
This is-
on that issue.
my lord, I was not the councilman. I can't say.
I did not,
I didn't. Also, my lord,
on a
this, I
cursory
did,
glance, I did not find.
and my lord, with great respect of the learned division bench, certain points, the is a code by itself. 69 is completely, with great respect, division bench is something else. My lord, 69 is something else. 69 is a collector and authority. Where you go to an authority, then 74. My lord, your lordship will kindly, I have gone to them. 74 appeal lies
Authority is that arbitrator.
Yes,
69.
kindly see. What is, see that, code boli, account code. My lord, see the act, this which they have raised. So let us clear this point, my lord, with the learned single judge, learned division bench. See, my lord, see, 69 kindly see. He was talking about an authority. See, my lord, in determining the amount of compensation, 69. Determination by authority. One is a collector and authority. Now you see, in determining the amount as awarded by land acquisition, include the rehabilitation, and the authorities shall take into consideration.
For that, you will have to come to the starting point would be 64. Starting point would be 64.
64, yes.
And
Six reference to authority.
64
So who is the
to
authority?
69
Yes.
is with regard to you. They don't
Yes.
have any role. Their role will come when 69 order is passed. 74,
74
all will
appeal to
come.
the High Court.
So
Appeal to the
till
High
that
Court.
time, they can't go upon an appeal before the authority.
That's
They
what
are
I'm
stopped.
saying.
That's
That
the
point-
scheme of the.
That's a scheme which is, I think that may not be.
I may be wrong in saying so,
No,
but
no.
that is my understanding.
No, yeah, right. That's why.
64, 69 is a stage of the landowners.
No, my lord, what happens here? Very interesting. What is 41? Your lordship is, now I am giving first reply.
You give me 10
to-
minutes.
Yes.
Yes, who is,
But-
Mr. Dole, you are paying for the, what is exactly your objection on 2 points? No, I want your preliminary objection on 2 points.
Yes.
One, that you don't require the land, they had done it on their own.
Yes.
Say, Mr. Dole, if there was even a letter from your end for requisition of this land, that's the end of the matter. That would be the end of, I'm just, my understanding. I'm just saying that if there was a need expressed and they have acted on that, that would be the end of the matter. The earlier decision would follow. Two, before the division bench, you had taken a plea that an attorney holder cannot come. Why?
My lord, that I'll come to. Prior to this, I want to narrate something before going to the
Hmm.
end. This Arunachal and China border, this is 1125 kilometers. They are telling you the facts. And to the defense purpose, sometimes for a helipad or for the defense.
We have been getting it day in and out day out.
Yes, yes.
We have been getting it day in and out.
And my lord, sometimes for a strategy changes. Due to the defense purposes, strategy changes in 1125. Apart from that, in all India, my lord, nearly I'm now telling you the exact figure, nearly 1,500 regiments. There are army. They are in different borders. Here, my lord, one mountain division, one major, he has written a letter to the deputy commissioner, we want this portion. This equate. He doesn't have the authority. Only a major of the mountain division.
So,
Yes, I'm coming to that. What
okay,
is-
okay.
Now-
That is your argument.
Yes.
Let us come to the, let us come to the 41 notice.
No, prior to that, my lord.
Just to test that. Let's come to 41. Where did you show me that 99?
99. 99.
Okay. And Balipara is
Section 10.
105. So is it your case, Mr. Dole, that all these things were happening? The Union of India did not know about it.
Some extent, yes.
Not some extent.
No, because what?
Either you know about it or you don't know
Why
about it.
Army is also Union of India. One major is also Union.
No, I'm not on that. The
No,
competent
that's
authority,
no,
the-
not competent authority.
the competent authority.
No.
Okay, now tell me, if this land is required for strategic purposes, who would be the authority to
DEO, Defense State Office.
visit defense asset?
State officer is the only
Okay,
authority.
okay.
If the Union of India need some airspace, some ocean
Okay.
space, some land.
So defense estate officer has to make this requisition.
Yes.
He is empowered.
He is there.
No dispute on that.
No.
Now, when did this defense estate officer come to learn about this?
Yes, then immediately what happened, a letter was written to the commissioner.
When?
I'm coming to that.
Tell me.
Just in 5 minutes.
Tell me, just some
5 minutes.
bad habit what to do, but this goes into the head, it doesn't come out.
Why I'm coming to something else. Before going to the proposal, your lordship may turn to page 103. This is important. 103. Before coming to the 2009.
Which is the page you want me?
Yes, 1039 is the
1039.
1039. Your ACR rule is minor 1035. Just
1039.
at first, your lordship will see 1035. 1035, this is ACR rules. Then coming to the appropriate, that is 1039. 1039 part 2, my lord, 41.
Acquisition of land.
Yes.
Acquisition of land for any of the above department will be carried out by the defense department, the request of and in consultation with the other department concerned, and in consultation with the finance department or any other government of India. So, so and 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 so. Half the market value, so and so, so and so, so and so. This is
Yes. Now your
and all will now be with regard to that.
yes. Now your lordship will come to the page 1041, section 5. Who is defense state officer? The authority will be ordinarily concerned by acquisition of land and brief description of their respective functions as is the matter. The defense department, this is it.
Authority empowered to give administrative sanction in each case and ensuring the complete record is kept over so and so, so and so, so will be responsible, so and so, so and so, so and so, so and so, so and so. Okay, done.
Yes, but the director of the defense officer will be that is.
I got it. So we lock in the fact that he is the authority.
He is the authority.
No,
My
when
lord,
for the
any
first
army
time-
authority, any brigadier, they are not at all authority.
Forget it.
to work
When
for
did
the-
he first time come to
Yes,
learn about this?
that I'm coming to that, my lord. But if your lordship tells the detailed scheme, how it is to be done.
We'll go into that. We'll do it. Preliminary thing. Preliminary things, Mr. Dole, we just want to hear.
Then we have to come to my affidavit in opposition where we have.
Take me to that. Affidavit or the additional affidavit?
Additional affidavit.
Okay.
Before going to the full agreement, just your lordship.
I just want that.
Yes, yes.
So then I can take up the matter
Yes,
on
yes.
minutes.
Yes, yes.
Because Mr. Das's opening statement, I've got the idea what it is. Now we got to fill in the blanks.
Yes, yes.
So you are referring to page 16 there, the letter dated 4/2.
That is in page, means 29. 29. To the deputy commissioner, this is the letter, my lord. Fourth, further you also request not to proceed with any action under 2013 unless sanction is received from the government of India.
No, I'm not
Minister-
on that. I'm not on that.
Yes, madam.
I am on the question that when did you come to learn that there was a acquisition proceeding being made on the request of a major, which you don't want to?
Yes, yes, yes. My lord, when the defense state officer come to know, they have issued this letter that your lordship will find as a page 27.
this is neither here nor there.
This is 2012, my lord.
This is neither here nor there.
My lord, generally.
I want to know that your major requested
Yes.
and that and that section 40 notification was issued. What is the date, Mr. Raka? What is the date? 41st notification?
40.
41, huh?
99. Please 99.
No, what is the date?
Or date. Date is
20th of July
20th of July?
2017.
20th of July 2017.
17. Okay. So, Mr. Dole.
Yes, prior to that, this letter was issued to them.
So connect it with that land. Kindly connect it with the land.
Yes, yes.
Because this is of 2012.
Yes,
This
my-
action is of 2017.
For a minute, your lordship, I come to page 30 also.
Yes.
Page 30, my lord. Withdrawal by the government notification issued earlier acquisition of the land for army. So when they come to know, they have asked to withdraw of the debt. And there are so many Supreme Court judgments that I submit to your lordship. So every the Union of India has every authority to do that.
So this is the first letter.
Yes.
2019, page
19.
30.
Yes, my lord. Because it was not required. Yes, it was taken on the rent, my lord. There were strategical reasons that was taken on the rent. Only the 2 acres, 3 acres.
Mr. Dole, if you want to take it on rent also, you're taking somebody's land.
Yes, my lord.
You're depriving him.
We are not depriving, we are paying rent for that.
Where is
Yes,
it?
that your lordship will find
Show
out.
me
my-
that from
Yes, yes.
2017 onwards, you were paying rent for that land.
Prior to that also, we have been paying, my lord.
Same land.
Same land, my lord. Different segments. Your lordship is just,
Altogether different land, Gita Mitu, it's a matter where they are paying rent. Our is, there is no rent.
That's what
But
I'm asking.
one query, I just, sorry for disturbing my learned friend. The lordship was asking very pertinent. So some letter, but that letter started from 2011, page 13.
No,
Of the
I'm
Government
not
of
on
India.
that. I'm not on 2011-12.
No, there's a principal approval is granted. That's what I'm saying. Who has granted, kindly see, my lord.
Page?
Page 13. That's the affidavit of the Union of India. See page 13, Union of India.
Affidavit.
Yes. An affidavit in opposition filed by respondent, Union of India, 124.
Wait,
See
wait,
that?
wait. Here, there is a difficulty.
So see that, my
It's
lord.
all, some here, some are there.
See
Page
that.
30.
Lord, we got it, my lord?
No.
Affidavit in opposition filed by respondent,
8 and 9.
124.
1 to 4, yes.
124. See at page 13. See at 13. See at page 13, 2011. From so and so to head, in principle, approval honorable Raksham has been accorded acquisition of 200 acres of private land at so and so. This is the place. The board of officers conveyed the preparing of board plan for obtaining sanction of the government for Eastern Commander. So 2011.
Okay. Let
Yeah,
Mr.
of course.
Dole please.
why not actually what happened, then subsequently, like my learned friend, I came to the case subsequently also.
I got it.
What about them reasons? But the fact is that, as I told you, my lord, it's 11.
Only the question should be too many cooks should not spoil the food.
Yes, exactly. Agree. Now 1125 kilometers due to the defense purpose,
No,
and due to
Mr.
the helipad and
Dole,
everything. So
This
now,
court is very,
yes.
very, what do you call that?
And
Understanding problem, manufacturing defects are there. So I don't understand things in a big perspective. I understand things in a smaller perspective. So tell me the connection.
yes,
You
now,
say that this is not there. Just show, I'll ask Mr. Das to do.
my lord, I just have take my additional affidavit.
Okay.
Take additional affidavit.
Interesting. Additional affidavit.
Because it is, this affidavit is done, because what happened is in that in such a way, actually my oral submission is not required. So that is why I'll rely on my affidavit on the minor. So your lordship see I'm going to the facts also, the page, paragraph 2. That the respondent beg to state that wherever land is required for the defense purpose, the process is initiated under a well laid down policy, and the same has not been forwarded in the instant case. The whole acquisition process also suffer from inherent legal defects, which the respondents want bringing to the notice of the honorable court. The Ministry of Defense follow a well laid down norms as a matter of policy of the acquiring the land until the act is
Mr. Dole, These are things which
Procedural.
you have to do.
Yes, I have to.
Now, if you have given an impression to the state that we won this land and their land was taken.
No, mine.
So we are not what is the, we will not see what is there beyond. We will say,
Yes.
how did you project?
So what I say, my lord,
My,
here,
Mr.
here,
Dole, what I am trying to ask you is what maybe I have not been able to communicate. My thing is that there was something which led them to issue that 41 notification. Maybe that authority who had done it was not the appropriate authority.
yes.
Now, what are the steps you have taken after you came to learn
after
that
the-
this is?
Yes, then we have written to the collector to withdraw their,
Show me that.
that I have already showed you.
That letter.
Yes, that later I'm showing you.
That is of 2019.
Your lordship has already seen at page 30.
30. Yes, that is
30.
2003.
That's 2019.
30.
Because we have been paying rent to them.
No, they dispute that.
We don't have any objection paying rent on that. And it is not possible to acquire actual uses, my lord, your lordship will survive these only 2-3 acres. That also we have stated in our proposition.
Page
30, my lord. Additional affidavit.
additional
Yes,
affidavit
additional affidavit. That is filed by Borsaso.
with reference to the so and so, so and so.
Borsaso, my lord.
Okay, now tell me. Now, Mr.
No,
Dole,
have you
you read that. You read that opening line.
yes.
Kindly read that open.
Withdrawal of the government notification issued
With
earlier.
the first paragraph, sir. With reference to the letter on the
With
subject,
reference to later on the
I am
subject side of the
directed to convey the approval of the government for withdrawal.
withdrawal.
So, there was an approval, there was a move, there was a need. You issued the notification, now that need is gone. So, you have taken an approval of the government for not acquiring that land.
Yes. Yes.
Is that the position?
My lord, initial notification was not for acquisition.
41.
Yes, even though, my lord, as I narrated you, because due to the mountain division, they are in charge of such a long area, my lord, in the border. As statically
Okay.
that is being
Now,
changes.
now we say that some officer of yours,
Yes, that
had
is
done-
army. That is army.
I mean, some
Army
officer,
is not entitled to do that.
what did you do against it?
Then we have asked, yes.
What
Now
steps
we
have you
have
taken?
written to them not to give such kind of letter to anybody.
No. Because this has affected a large number of people. He has acted beyond his authority.
Yes, ma'am.
What steps have you taken against him? You're the Union of India. What steps have you taken against him?
I think, my lord, here, my information is they have warned them not to do such kind of things in future.
Warning will not.
After all, also, if they have done it, I am not aware of that.
Because see,
My lord, I was come to page number 67
oh,
of the petition. This is the letter issued by Defense State Officer
you are appearing for?
for Land Management Department.
Okay.
This letter shows that, my lord.
You mean to say this is the letter which led to the issuance of the 41 notification?
Yes, no, sir. From page number 68, no, sir, we can draw. In fact, from this copy to page number 68, here it is copy to Additional Deputy Commissioner Haidang Anjao, Arunachal Pradesh. For information, please, you are requested to forward the following land acquisition documents as per LAR Act 2013. And this letter has been written by DEO.
He is the authority.
He is the
Yes,
authority.
he is the authority. That only Lordship I want to talk.
Not only
From
that,
this document,
sir,
Lordship.
kindly
There is
Yes,
so many
Mr.
documents.
Yes, Mr. Pal.
Reference letter.
Maybe the brief has
NOC.
come to you late. You have not been able to
NOC.
connect up. I can understand. Otherwise, Mr. Dole does not go.
No.
in this manner. He goes direct to the point.
My lord, this sort of communication we have also in our affidavit, my lord. It's a communicated by the.
I'm coming to you. I'm coming to you.
And my lord, what are the reasons? Here, again.
No, we are not that. DEO has written a letter.
Yes, my lord, that letter I have seen, but now the question has come. Once it is DO has come, there are Supreme Court judgments, I'll submit your lordship. Whether that can be withdrawn or not. That question is also there. The Supreme Court says yes, If India feels that that land is not required for the public purpose, that may be withdrawn. Reason is, my lord, that I have rated what are the practical positions your lordship will show.
Now they have lost their land from 17 to 19. They are not in
We are
possession.
paying rent.
They say they are not receiving rent.
The lordship will give it the direction to pay the rent.
We'll
That-
not-
that-
we'll not-
Because
Why should
what
they
happens,
accept
is it possible in such a sensitive area for government of India to acquire 1125 kilometers for entire the country, all the ocean, all mountains? Is it possible?
Where is that letter you showed me now?
That year,
Page 60?
no.
67.
67.
There to the strategical reason
this
the three
is-
changes.
This is 177.63. How much is yours?
170 is 177.
Exactly. Yes.
No, kindly see for that, not
So
that.
your answer is here.
Yes, that is there.
My lord,
Now I draw your attention in another way. What are the reasons where your lordship will set page 49 of my affidavit in opposition? 49,
Affidavit, additional affidavit.
additional.
49.
What is the practical situation? What are the practical situation? Only just I'm drawing your attention, my lord. Now, in reference to 2 mountain division letter showing it is submitted that the joint survey of 177.66 acres out of 200 acres of the land in the following area under Choklagam Circle was completed.
So,
at-
Mr. Dole, that means the Union of India made a wrong submission before the division bench.
yes.
I can understand this. There can be only two situations here. One, you did not.
Yes, it was not properly pleaded.
No,
that
no,
might
no,
happen.
not properly pleaded. This is not called for. You have misled the court.
Sometimes that might happen.
See, my lord, what?
Entire
And I'm sorry to
A single judge's order has been interfered with on the plea that we did not give any
yes,
sanction for this land. This was a unilateral action on the part
that
of
was not stated before the
Yes.
court.
one.
Yes,
No,
right.
that was stated other way around.
Other way.
Other way around.
Yes.
Two, because of that, now what we see is you had wanted this land. Subsequently, maybe for some strategical reasons or for any other reason, you had said, okay, we don't want this land, give us land B.
Yes.
Fine, we will examine that. But the matter is now remanded back to me
Yes.
to decide an issue
Now your
that you did not have option. I'll
Yes.
decide that.
yes.
And I'll
My-
say that this is
my lord,
not
yes,
done.
your lordship is absolutely right.
Whatever
It
happens,
was-
happens.
That was not there, not narrated properly before the court, my lord. That is true, absolutely.
Mr.
Now,
Dole, you were
what is
not
the-
there. You were not there, so you can't
Yes.
say exactly what has happened.
Yeah, yes.
So we will have to
But I
draw
came to know the officers.
No, we will have to draw inferences from the order itself.
Yes,
See, come to para 5 of that division bench order.
yes. But prior to that, what is the present situation? May I draw your attention? Madam? Yes. That is your page 49, madam, that you have seen. What is happening? How the situation changes? That I want to
No,
bring before
fine.
your lordship.
We would have understood a situation
Just
in that
let
manner.
me
See,
let me
this,
read it.
Mr. Dole, this situation was not explained before this court. Requisition. It was not pleaded. It was not projected in the.
Absolutely,
So
right.
what
right.
is the consequence?
Yes, right, my lord.
Got it.
Now I am coming. What is the situation, the present situation, my lord? Because the above mentioned joint survey was carried out considering the prevailing requirement of the DO Delhi Valley and then available in infrastructure, including the surface
You
command.
need not take the trouble. You can come to para 4 last line. With that same letter, page 49, para 4 last
Oh,
line.
however, yes, that is the.
Therefore,
It has been reliably known that the road of Hailung and Sanklagram is being improved by BRTF, which is facilitates smooth movement. In addition to road with NHSL specification is planned to be constructed by BRTF connecting the Khaparu and Rocham with Sanglam. Therefore, earlier requirement of equivalent will not require to be pursued.
so this
Yes.
land,
Not how
this
situation
is
changes.
by your major again to the defense estate officer.
Yes,
That means
that-
what?
That's the
The
information.
earlier requirement of acquiring land
Yes,
will
yes.
not be.
No, that
required
is
to be-
informing to the department to department.
Fine, he's-
Department to
that- but
department, that information has
letter-
been given.
That letter shows that there was a requisition made earlier. And that too by the defense estate officer. Otherwise, why should it be returned to the defense estate?
Yes, definitely, my lord. That is. that-
2018.
The 18. After those, no, I got it. I'm only trying to explain as to what is the situation. Because what is projected in the repetition, we don't want the land. Right away. You did it. But here we want the land. But now we don't. Both are different.
Yes. my lord.
And they're all information that what my learned friend, Mr. Kamtikar said 67 has shown, not only 67, from 67 to page, Lordship sees up to 86. Kindly see what is this, my lord, 67. And today 18 you are coming and say we don't want the land. Kindly see 67.
Join.
See at
No, they,
69.
no, page 14, Mr. Dole is very fair. He has taken me to a document which admits joint survey.
That's right. So 89, kindly see 89.
Okay, fine. We
Yes,
got
sir.
it.
Apart from that, my lord. Apart from
No, preliminary, this much is enough. Preliminary hearing, this much is enough. Yes, Mr.
No,
What
my-
is your-
My lord, just I was citing case laws regarding that.
You just reserve it. Just
Okay.
reserve it. I'm not deciding it today.
Yes.
Don't worry.
lord.
Yes.
My lord, the Land Council for the Union, my lord, have rightly said, my lord, unless approved by the Union government that this much of land is required, and the state official, different state official is the authority whom the central government authorized. Now he says, my lord, in the division bench here also in the starting that there is no such requisition. But when you, my lord, see the documents, but this will
Show
then-
me one document on
Yes,
which
ma'am.
you
in our
initiate.
affidavit, but you will kindly come to page 11, my lord.
11.
Yes, this is the first letter written by the state official for joint survey, my lord.
Affidavit of respondent number.
Respondent number, my lord, is.
Mr. Pugan, who is the state respondent here filing affidavit?
Yes, sir. Two of them have filed it.
Because I did not know that there was a different. So I should not go through it.
Union, one by the state.
No, state.
That is.
Are
8 to 10, 8 and 9.
8 and 9.
Yes.
Okay, got it, Mr.
My lord.
Hmm.
If your lordship see, page 11, my lord,
Page 11.
filed by the deputy commissioner.
9, 10, and 11.
Yes, my lord.
Certificate for joint survey.
My lord, dated is 13/12/2016.
Hmm.
Your lordship see the down below, my lord.
Now you can come to page 9 also. So and so defense estate officer.
No, my lord, in our affidavit, my lord, we have not annexed any documents 9, my lord. That must be
Affidavit is by whom?
by deputy commissioner, my lord. For the deputy
Respondent
commissioner.
number?
8 and 9, my lord. 8,
Ah, this is 8 and 9.
8 and 9.
By one Mr. Tanatoto.
Yeah.
Right?
There are two of them. One is a slightly
No, my lord, this is
heavier one.
Rupir Sibo, my lord.
This is
That's a small, there is a.
1 to 74 is marked as 3. It's filed on 12th of November 2018. There's a slightly bigger one.
12th of November.
12th of November 2018.
Only one affidavit.
There are two affidavits, right? My learned friend is
One is filed by the, my
Yes.
lord, Secretary Land Management.
Rupir Sipo.
Rupir Sibo is for respondent 8 and 9, the deputy commissioner, my lord.
No, Rupir Sipo there.
Yes, sir, I'm referring to Rupir Sibo.
8 and 9, yes.
Yes, sir.
Rupee Sibo.
Yes, ma'am.
16 November 22.
Correct, ma'am.
Para, page?
Page 11, my lord, annexure 1.
Yes.
Huh.
Yes, my lord.
Hmm.
So, my lord, dated 13/12/2016, my lord, addressed to the deputy commissioner by whom, my lord, down below, my lord, different state official.
Okay.
Now, based on, my lord, it's a requisition for joint survey.
Hmm.
Then, my lord, your lordship only state, my lord, page 67, the report of the joint survey.
No, I've seen that.
Requisition,
Hmm.
and that has been provided to a higher authority, my
Hmm.
lord. Now, my lord, on what
Where is that clearance after that joint survey?
clearance, my lord?
Hmm.
My lord, after joint survey report, my lord,
The
the,
joint survey, the requisition stage has not arrived.
my
You
lord,
have, they have seen
Ma-
whether
they
it
have
is
seen it.
feasible.
yes, my lord, they have
Now-
seen it. Then, my lord, the estimate was sent to them, my lord.
Hmm.
But this much amount is required for compensation, my lord.
Hmm.
So that was sent on, my lord.
17th of March 2017.
Eight petition they have
87
allowed.
of the writ petition.
Yes, sir.
87 of the writ petition. 387 of the writ petition. 87
Hmm.
of the writ petition.
Okay, what is the response to this?
I think there is nothing. This
So
again,
how
page
is it?
89, page 89. This was also sent with the
No, I got
estimate.
it.
and
This
also
has
got-
to be approved.
Yes.
Where is that approval of the government of India? Before you issued this notification, there has to be an approval to this estimate.
My lord.
Where is that?
My approval, my lord, we have not annexed, but estimate was sent to them after joint verification, everything.
Mr.
My lord, I
whether
got
the-
it, my
no.
lord. Yes,
Whether the joint verification itself
my lord.
is the requisition. If you satisfy me that joint
There
verification,
is, as to my knowledge, there is no approval. It is only in principal approval was given. 2017, it was forwarded
so,
to
so,
defense estate officer.
so Mr. Das,
Yes.
first thing is a joint survey.
Yes.
Yes, my lord.
So they made a joint survey.
Yes.
Once a joint survey is made, that means the area is demarcated. Thereafter, the estimate is prepared.
Yes, my lord.
This has to go to the requiring authority. The requiring authority has to give
Now-
a seal of approval
No,
to
no,
it.
that's why I'm saying, my lord, your lordship is asking that whether after this, when it was sent, whether there was approval which was granted.
Or
to
they
the-
should have given a
No, no,
principle.
yes, it is not there. Well, let me,
Then-
then whether in absence of approval, when you issue a notification under 41, irrespective whether there is approval, whether 41, what it 41 says. Number one, whether we are entitled to get compensation or
I'm
not.
not on that.
No, but there's a
Then,
very major.
then, Mr. Das,
Yes,
when I direct for a compensation to be paid, I'll also have to identify the authority who will pay.
yes.
If the Union of India cannot be settled with that burden because they have not given, that's loud thinking.
Yes, yes,
They have not given an approval to this.
yes.
Then Mr. Dole cannot be put to,
Then, my lord,
But
but
the
then-
state will pay you.
No, now there is one, my lord, one clarification I'm just making.
My lord.
you have taken pay.
My lord, the assessment was sent to them. My lord, for final approval and for payment of the one. My lord, after that, my lord, there is neither they have rejected the my lord, assessment nor my lord.
Now tell me, on what basis did the Secretary Land Management proceed to issue this notification dated 27/2017? That is March and July,
My lord.
4 months.
Oh, my.
Where is your records? Where is the records preceding this? Yes.
My lord, all the writ petition was.
We are just trying to understand the scheme, that's all.
Yeah.
Now you send us you tell me whether the joint survey is enough.
Because, as you have seen from the document at page number 17, the letter written by the CEO. So. this
Letter
CEO
written is for a joint survey. You have done a joint survey.
Yes,
You have sent the report of the joint survey.
yes.
Now, is it not required for you to get a clarification whether that is satisfactory or not?
Because was all along there was no objection from other parties because they were willingly participating in all this process.
Not they.
Yes,
They-
yes.
No, I'm not on that. It's
They are
it's an
required-
administrative action. What is the point? Why did you then send it to them? You could have directly gone for 40. Why did you send it to them? What is this joint survey? What is the implication? Where is the office notes leading to this issuance of this 27/2017?
That also we did not file affidavit with this writ petition. But while taking up this matter on one occasion, this honorable court has directed me to produce some documents, original document at page number 116, 18 and 120.
100?
16, 18 and 120. So according to the direction of this honorable court,
No, we are not on that. once the issue has come back, and the issue required to be decided by this court is that the Union of India had not given any approval. So that's an issue which we decide. But now you say that you have sent this, what do you call that? In connection with so and so documents, you have sent the documents. Now, where is that satisfaction that, okay, fine,
Certificate is there, Lordship.
satisfaction
Yes,
of
sir.
the Union of India that, okay, the joint survey is perfect. Go ahead.
We just received any letter from Union of India, but Lordship, there is a certificate of joint survey, page number 70. Lordship.
7-0 of the affidavit, the writ petition.
There was a reference of this DEO also, but it was stay on the bottom, at the bottom. DEO was represented by S. SDO. Pratap Chand for 8 Jamal Takur Drive.
Okay, fine, done.
Now, after all these processes, there is no requirement for this government district. Requisition letter from the DEO.
That we will examine.
Just one point, which clarifies everything, I think, my lord. One paragraph I'll just read. What happens when the government takes the possession of the land? Whether it can
See,
be reverted.
Mr. Das, here the situation is slightly different. Here we have 3 layers. Last layer is the land or the landowner. Top layer is the government of India. And the intermediary is the state government.
Yes.
So state government has taken over the land on a belief
Yes.
that the Union of India requires it. But what is yet to be very clear is whether the Union of India required it.
No, one second, my lord, I just trouble your lordship in one of the judgment, kindly see, that will really help, I think.
Please do so.
1993 4 SCC and another 4 SCC 369. Kindly see the judgment.
1993.
4 SCC 369 by three judge.
Name of the party?
Satyendra Prasad Jain and others versus State of UP and others. See kindly 15. See 15. 315. Ordinarily, lordship got it? Three judges. See kindly 15.
This is under the 2011 Act.
Yes.
Earlier
Parallelly
one.
across the same parameter. Ordinarily, the government take possession of the land proposed to be acquired only after an award of compensation in respect thereof has been made in section 11. That's why I saw is apart. Upon the taking of possession, the land based in the government, that is to say, the owner of the land loses to the government the title to it. This is what section 16 states. The provision of section 11A are intended to benefit the landowner and ensure that the award is made within a period of 2 years from the date of section 6 declaration. In the ordinary case, therefore, when government fails to make an award within 2 years of the declaration under section 6, the land has still not vested in the government and its title remain with the owner. The acquisition proceeding are still pending and by virtue of provision of section 11A lapse. Now see next.
I've seen it. Go ahead.
Kindly see next.
I've seen it.
When section 17(1),
Is it?
kindly see, 1 is applied by reason of urgency, government takes possession of the land
You lose your.
prior to making, so you lose. That's what, my lord.
But
Exactly.
Mr. Das, state has got no headache here to acquire land. They acquire on the basis of some requisition made by some authority. Now that is disputed, and I have to go into that
No,
because
that's
I've been asked to go into
No,
that.
that's why I'm saying, if there is a dispute between the Union of India and the state, So why I will suffer once you have taken under section? Why I should
Because
suffer?
Mr. Dole would
No,
would be relying on judgments. He has said.
No,
Wherein it said, in such situation, the land will revert back. to you.
no, that land cannot be reverted back of this situation. That's the because of
17-1.
statute.
I got it. If the
Because-
Supreme Court
but-
has dealt with 17-1,
17
you have decisions of 17-1,
Yes.
17
just give a list.
Not exactly.
Just give a
My
list.
lord,
Yes.
it has to be, I have gone through it. It is 17-1 is paramount to 40.
40.
And there is no question, I'll show other journal, there is no question of any reversion to us. One. Now today, what is a dilemma because it is between the union and the state. Today, what happens to the landowners? Now suppose
Nobody is worried.
state is saying will not pay because this is meant for the government of India. Government of India will not do. Why we will do? But because there is no approval.
That is why the
Now,
matter
very
has been
interesting.
placed before this court.
Now, very
by the
interesting,
division.
I'll show it. When it is required and what is the power of defense asset officer? I can give a reply what
Fine.
my learned friend has shown.
We will not detain you any further today because there is no point. It will
Tomorrow
not
we
be.
continue, man.
No, not tomorrow. Don't worry. We'll have it. I'll take it with me in Guwahati. They can join from online. If not, otherwise inconvenient. If you agree, I'll keep it.
My lord.
Yes.
Your lordship was querying for the, my lord, land owners, my lord. We have the records, my lord, all land owners website. We
There.
have the records. Then secondly, my lord, after.
When?
Hey,
Whenever it's convenient to you.
My lord, my lord, after.
Will be in Guwahati. From
Yeah.
there.
My lord, I marked
He
the,
is
Online.
very tech savvy. There is no problem with
my lord, I marked the, my lord, then acquisition, my lord. After the.
it. No, we don't want it.
My
You
lord,
keep it with
I'm
you.
just improving, my lord.
We
After
keep it.
completing
I got
the
it.
exercise,
I've
my
got
lord.
an idea.
My lord, now this has been sent to the authority, is that the officer?
So you get hold of your records. The note sheets pertaining leading to that 47. 41 notification, just get hold of them. If required, you can give me soft copies. I'll give you the mail ID of the court. You can give soft copies. Okay, so when?
Any date which you
Whenever.
I am there. Next week.
Second week of June, my lord. Second prolonged.
Yeah, one thing is there, I will tell you a lot to you. That there has to be, I can your lordship. I wish that your lordship, but there one order of chief justice is required. Your lordship remembers one matter of Arunachal Pradesh.
क्या procedure?
That's my view, my lord. I don't know. I should say as a senior counsel.
हाँ, ये अगर मैं पाठक रखता हूँ तो वहां जाके सुन सकता हूँ परमिशन लेना पड़ेगा लेकिन we'll have it. You need not be here. We'll have it at 10:30 tomorrow.
No, I'm here.
We are here.
Yes, sir, yes, sir.
I'll just inquire and then I'll
10:30,
call.
I'm here, my
You cannot not be.
Then I can give my.
You can leave.
Yeah, I can give. Then my submission I have already given.
Got it.
Further argument I'll make it.
I
for
will
your
happy,
convenience.
but I think that I should tell you.
No, fine. If
Because I
that there
very
is any
happy.
Otherwise,
Because I was comfortable in Guwahati.
Yes.
anyway, I'll be coming back maybe second week of July.
yes, we can come.
But your lordship can take this, absolutely no problem. There is no problem.
I'll
But
just
one administration, I think your lordship will just,
I'll just consult the senior judge and I'll take.
yes, right, that's all.
Because
It
I've
will
done
be
that.
easier, it will be easier
It will
for
be,
us
yes.
if it is there.
I've done that.
Yes,
Yes.
that's why I'm
List this matter again tomorrow. Just with my order.
But tomorrow, my lord, I will not be here.
You need not be here.
Oh,
he is no, why he is going, I am telling you. He wants to play golf. That's why he is going.
He has a very good.
Oh, my lord will not allow. He will not guard.
No, then
He
I'll
will go now.
then I'll have to face the music from somewhere else
I know.
because I have been invited. I have been also asked
I have been asked,
that you should come and play.
I have been asked also.
I said that you are free now. If you can also spare some time for that part for me, then I'll come. He is really into it.
Very much. Very much.
Justice Bhuyan.
Yes.
My lord, we don't have that sort of facility to golf, but
Come
badminton.
down. Come down.
People are coming
will
from
provide
Japan to play in Bangkok.
We'll provide you.
I have not reached that level.
In Guwahati, we have a good facility.
Very good
But
person.
Shillong, I know. Shillong, yes.
Shillong
Guwahati,
it is.
Army camp.
Army camp. Okay.
You can take
Yes,
this
Sir, is there army member?
tomorrow. Let me have a.
Tomorrow. I'll let you up.
Oh, matter. Oh, June. Huh? 18.
Why not? Your lordship should not have allowed him. That's why I say no,
No,
I
I'm
will
not
keep.
allowing him for that. I am allowing him for some other reason. Otherwise, I'll have to bear the music from the other.
Keep me honest. I think one matter is with Tiwari is there. One election matter is there before your lordship. One where lordship can I think can be a lordship was appearing. Where one Panchayat election.
Oh, I can't. That one which I argued before the which one?
I'm appearing. That's it.
Item 20? 20. Oh.
There is some urgency in this
Okay.
case.
List this matter again tomorrow.
No, tomorrow, my lord, on 11th.
As list this matter before any other bench without me. मेरा नाम लिख दीजिएगा. What's up? An urgency has been expressed by the parties to the proceeding, and accordingly, registry is directed to take steps for listing the matter before the appropriate bench in the on a date to be fixed by it. You give him the date. He'll do.
But I will be happy if it is because.
I should not fix the date.
Yeah,
because
no,
of-
when, so restricted.
It has come out of where? Stay is there. It's under stay.
No, they have all. Lordship appeared for the private restaurant land.
I forgot.
So we lost. I was not the council. Now I have been invited here. Deeply honest.
Then I am the best just to take it up. I know the facts. Yes, Mr. Apan. Sorry to have kept you waiting. Yes. I know, that I was looking. Yes.
The only thing is, not director, he's not even 1 year now on joining.
That we are not concerned.
But by request. Now, this matter is still taken up by Board of Management only.
The order is already there. High Court order is already there. Place that order. Where is that?
Another order is also there.
Page content to 20, page 74, madam. Contempt was withdrawn because the impugned order was passed and a new cause of action arose.
Came.
Order was placed before the honorable court at the time of withdrawal of the contempt. If I remember correctly.
So the decision is 12/1/2016. Preferably within a period of 3 months from the date of certified copy.
Yes,
Then you pass that order,
yes,
and thereafter the contempt order came,
yes.
right?
So, in contempt,
Contempt was closed, my lord, because a new cause of action arose.
That we will not go.
That does not mean the order dated, the
No.
undertaking.
Has
given-
been
Yes,
washed away.
Yes, cannot be.
my prayer is also, the Board of Management is having meeting on the 11th of coming month. So, it's an agenda here, the number I think, 3 to 9. So, let the matter be discussed after this also. It might so happen that earlier.
We can't go on it, Mike.
My lord, if the instruction was that we are placing it before the board for re-implementation of the earlier order, then I could have understood, my lord, but that is not the prayer being made.
You make a submission. I'll still let you go. That you are going to implement 12/1/2016. That's what you want?
Yes.
That we will, okay, why board? You go to the government of India also, I have no problem. But you give me make a submission that we are going to implement 12/1 and we'll withdraw the other order tomorrow morning. I want this to be implemented. I'm going to get this implemented. You ask here, who is your officer? Competent. Who would be the competent officer? We will not call the vice chancellor naturally. But who should be there?
I have never met the director. Director is a competent authority.
Ask him to come. Ask him to come. Offer him a cup of tea. We'll have a discussion with him.
He's absolutely not understanding, my lord.
He's not understanding. I've seen the last day notes. He's on a view that the contempt has been closed. That would mean that his order is upheld. That cannot be.
Cannot.
Now we are examining the validity of this order.
Neris was not sitting idle. Neris has been doing their job, but because of the COVID, because of not having
Mr.
members.
Mr. Apang, come to page 73.
Yes.
73. I'm not with the consequences here. I'm only with the implementation. The petitioner may get 1 rupee, he may get lakh rupee. That's a different thing altogether.
No,
But I am on this. The chairman, board of management has kindly accorded approval for re-implementation of the office order of even number dated so and so regarding upgradation of faculty members for placement under CAS from the eligible date on individual basis and sanction of financial benefits as applicable to them from the date prior to 1/1/2004 and granting of notional benefits for all others in their future promotion placement without financial benefits along with normal increments. Any so and so, forget it. Arrear, if any, will be released only when I understood this
Yes.
also. Now what have you done here? Page 87. That's the order on
Yes.
which the contempt was
Yes,
closed.
yes.
So, any person prior to 1/7/2004. So he is covered. His cash promotion is 2003. So he's covered by that.
Yeah.
Then
Lordship may then finally turn to page that L series connection.
page.
L page number is 86. Petition only, Lordship.
This is what we are imputing, madam.
This is what we have given them, Lordship.
Hmm.
Now, so far financial matter is concerned, I'm as a individual person, I'm nil about it, Lordship. How pay is fixed and all. So once I call up
You want that,
the
you want that to be done.
Lord,
We'll do it for you. Don't worry.
so
Okay. Tell me that claim that you are claiming as of 2003, 28/5/2003.
Madam,
That scale that you are claiming as of 28/3/2000, 28/5/2023. I got it somewhere.
I have given a chart, madam.
Where is that?
That starts from page 38.
Yesterday I did not go through it. That's the problem.
Page 38, my lord. P1 is Professor B.D. Nayak.
Okay, yes.
Yes. 50,430 is on 28/5/2003.
Where, 28/5? Where do you get it?
Yeah, in the middle portion, my lord. And on the right, what I am currently drawing and what I am entitled to. 50,430.
50,430.
In any case, my lord, they are admitting that the earlier they had given it there. They then kept it abeyance.
The authorities have not understood the purport of this letter.
Yes, yes.
What the letter says, there is two categorization made. One who is there from prior to 2004.
Yes.
And subsequent.
Yes. All the petitioners are prior to.
Lordship, there are more than 44 lecturers having the same thing, Lordship. So
We are not worried. We are worried only with these people here before me.
My lord,
then
I don't want to say the same thing again.
our calculation, Lordship, we have I have shown it,
This is
Lordship.
wrong. Show me the justification for this calculation.
Lordship, at the outset, I have said,
No,
Lordship.
you have filed an affidavit here.
Yes, yes.
Show
We
me
have
the-
filed affidavit.
My lord, they are only saying, my lord, is being considered.
Nothing is here.
Nothing is. They are not saying that what they have given us now is in terms of the earlier.
Lordship,
They
my,
say it is under examination, my lord, you see at paragraph 17 of the affidavit. and review of experts committee. How can they say this now?
Lordship, our
See, I'm only withholding my hand is only on one thing, the man has retired. People have retired.
Yes, yes.
And if I pass a direction today, then you will not implement. They'll have to file a contempt. Another 1 year, 2 year will go. I don't want that situation to arise.
Lordship.
I want you to implement it.
That's well, Lordship. Since the matter on 11/6, the Board of Management meeting is fixed, and this is already in agenda. We have set up a committee wherein they have done their work. So that is going to be placed before the Board of Management on 11th of this month. And now my prayer is that let the matter be listed after 11th of month. It might so happen that Board of Management, they have Lordship calculated in right perspective advantage to the petitioners may not
My
be.
experience with universities, it doesn't happen.
Lordship, we had, as per records, we
It
had
doesn't
tough time looking experts.
No, we'll have
For-
to answer this. I don't want to be harsh. That's all.
That's
That's why I gave you opportunity.
Lordship, I know
Apparently,
Lord,
the message is not getting across, man.
Hmm?
Apparently, the message is
That's
being-
not gone. Where is the High Court order, last order? Page?
Page starts from 74.
Ah.
Then, my lord, the operative portion is
Okay. Mr. A. Apang Lanet, Senior Counsel, on being instructed, has submitted that the university authorities have not responded
Lordship,
to.
they have responded, but there is no such improvement. So I can produce a.
no response to the 22 order, madam.
Have not responded in the manner required. And accordingly, he is not in a position to address this court with regard to the queries that were raised in the matter on the hearing held on 22/5/2024. Full stop. Mr. Apang on instructions have submitted that, Senior Counsel on instructions have submitted that the matter of the present petitioners is presently processed for placing before the board on 11/6/2024. And accordingly, he prays that the matter be heard after 11/6/2024, inasmuch as the board is yet to take a call in the matter. Full stop. The prayer is objected to by Mr. D. Panning, learned counsel appearing for the petitioner, who contends that there is no further requirement of any consideration being made in the matter, inasmuch as this court has already determined the issue involved, while order dated 27/4/2016, passed in WPC number 91 AP 2014. Full stop. I've heard the learned counsel for the parties. It is seen that in the earlier round of litigation, by and between the same parties, this court, while order dated 27/4/2016, passed in WPC number 91 AP public 2024 to 2014, had passed the following directions. Observation and directions, which was of the same being following observations and direction, page 80 A to A. Page 80 yellow flag, 80 A to A. Full stop. The above noted directions as passed by this court was so done basing on an order dated 12/1/2016, passed by the university authorities, wherein the competent authority had accorded approval for re-implementation of the office order of even number dated 95,6/11 September 2013 regarding upgradation of faculty members for placement under CAS Barawala from eligible date on individual basis and sanction of financial benefits as applicable to them from the due date prior to 1/7/2004. It is to be noted that the petitioners herein were placed in the said scheme prior to 1/7/2004. Right, Mr. Pani?
Yes, ma'am.
Full stop. The issue now being contended to be placed before the board, this court is not entering into, is not proceeding to finally consider the issue involved. However, it is directed that the board in the event examines the matter, such examination shall not be in violation of the directions passed by this court-wide order dated 27/4/2016 in WPC number 91 bracketed AP/2014. That is to say that it should not be in violation also of the order of the university authorities itself dated 12/1/2016. Full stop. The decision of the board in event is in favor of the petitioners. There would be no occasion to further proceed with the matter herein. Full stop. Even if the decision of the board is against the prayer/claim made by the petitioners in the present proceeding, there would arise no occasion for the petitioners to assail such decision inasmuch as the court is already in session of the matter.
Right.
Full stop. List this case again on when?
After 11.
After 11, any time.
My lord has
I think
Take it.
nothing more is there.
nothing more.
Directly to nine, indirectly, I think I've done it. When?
If
Week
it's-
thereafter,
Week
Yes,
thereafter, week thereafter.
19. List again on 19/6/2020. I hope before I come back, this will be resolved.
Hopefully, my lord.
From my side, Lordship, it's always there.
Sir, man, we
My
are
lord
not
has been
telling you.
very
we are
kind, my
telling
lord.
you.
Otherwise, my lord, the
Other-
directors would have been here tomorrow.
I did not do it,
Yes.
literally, because I don't want to escalate this situation. I know how they react. So
Otherwise, my lord, after your lordship's 22 order,
They should not
that's not getting across.
anyway, I have learned a lesson how to deal with them now better.
Lordship,
If I had 2 days more time, I would have disposed of the matter, but now I don't have time.
obliged, Lordship.
Obliged.
Mr. Pani, I think
This
It is
should-
done.
This should,
they should done doing for you.
we'll have it placed before the board of management.
That's it.
My lord.
मैडम ये मार्केट दे दीजिएगा. None appears for the parties. List. What is it?
Bail application. The bail application.
When was he arrested?
He was arrested on 8th April.
Hmm? First
8th of
round.
April, Your Honor.
First round.
He was-
First round bail application.
No, Your Honor.
Earlier you had come.
Initially, this honorable court had granted bail to the accused person on 30th October 2022.
Then
And then thereafter, he was attending the trial. However, he had missed out on 3 occasions, but dispense petitions were filed. So on the last date, there was an NBWA that was issued against him. So because he could not be present before the court, and then on 8th of April 2023, he had come before the honorable court, and there was a petition that was filed for recalling the arrest warrant. However, the honorable court had arrested the
Rightly so.
person then.
what is the stage of the trial?
Appearance of appearance,
Appearance of it.
appearance of accused persons.
Yes, what do you say?
As per record and close here with the petition, without taking steps,
I have seen it.
for non-appearance, non-available warrant of arrest was issued. Now, on that strength, he was arrested again. This is a NDPS case, indefinite range, and he is connected with another case in other state.
Other state also.
Yes, so more than 100 kg heroin.
Is it
Sorry, 1 kg, more than 1 kg
what
heroin.
Miss T.Y. Bhutia Laman? Yes, final consideration, or you want to have a further
Or
breathing space?
LCR may be called for today
LCR is not required. You have brought on record everything.
because there are
You have
certain.
brought on record the orders also. What more is required? We believe you. Then,
Then Your Honor, I may be given some time for placing my arguments because
Miss, on the prayer of Miss TVI Bhutti and Learned Counsel for the petitioner, list this matter after we on a date to be fixed by the registrar. Conduct is very bad. Yes.
Obligation.
Yes, madam. What is your instruction?
Lordship, from our side, Lordship, we have forwarded Lordship the order and
Not
for the
received back.
instruction. Not Lordship, not yet Lordship.
Ms. L. Hage, Learned Counsel submits. Learned additional public prosecutor appearing for the state submits that she is yet to receive instructions with regard to the query made by this court, while the order dated 27/5/2024, and accordingly prays that the matter be taken up after a week or 2 weeks.
Lordship, next week, Lordship,
Next week.
after a week, Lordship.
After, also, registry to list this matter again on 6/5.
6 maybe.
Your 2 means, okay. You have to receive that. Mr.
I'm the right person.
You're the right. We have just been troubling.
Yes.
Also, list this matter again on,
7, Lordship.
7/6/2024. Miss T.Y. Bhutti, Miss L. Hage, as well, Learned Additional Public Prosecutor, as well as Miss G. Ete, Learned Government Advocate, Additional Government, Senior Government Advocate, appearing for the respondent number 2, shall receive instructions with regard to the query as raised by this court, while the order dated 27/5/2024. It's only that she had
Lordship,
given a photograph, whether she has removed that obstruction, that much only.
they have come against the annexer 1. Lordship.
See, annexure 1 without drawing a preliminary order, they have,
General order, not against him only. This is.
but he says that it has been affecting him. It's 133. It has to be 133 has been involved. See 133. So he is involved. He is affected. So how can you make it a final order? You should have made it a preliminary, then a final one. That's why we have posed that you remove the that obstructions. And she says she has done it. Have a conference. Have a,
We'll come with the proper instruction.
just have it. Both of you,
Yes, sir.
both have it. Whoever it is.
7.
7?
Can you pay on 8?
8.
Saturday.
8 is a holiday. If you can ask the judge, I have no problem.
Of like
7.
Lordship.
Lordship on the last occasion, yes.
Dispose of.
Deeply.
Next time, this should be in your main petition. Get my point? This should be in the main, not an addition.
Actually, Your Honor, as per the earlier order, additional application should be filed. So that is why I
I'm allowing your criminal petition. You don't want it allowed.
for the, my lord, that is the additional epidemic for criminal petition. 75/2024.
What do you want it? What do you want me to do?
This is the additional epidemic.
What do you want me to do?
For dispose, my lord.
I have already disposed.
My lord, sir. Okay,
नाम लिख दीजिएगा तो।
please, Lordship. Lordship, this is an application under section 482 of CRPC for quashing of WPS case number 4/16. The dispute is regarding the husband and wife. It's a 498A allegation. So, Lordship, the petition has been filed by both the petitioners jointly after compromising.
Where is the FIR?
Page number 18.
18.
Page number 18. FIR against Tar Megu and Sri Vengia Juda for malicious conspiracy to physical assault by Dow and cheating.
Just so.
Also.
Where is that settlement?
Lordship, page number,
52.
yes, 52. The joint application, Lordship.
Okay. Where is your statement that they are cohabiting after this together?
No, right now they are not living as a husband.
They have divorced.
Yes.
Where is the divorce?
Not divorced, but they are not living together.
On the prayer of the learned council for the parties, list this matter again next week.
Lordship, till then, matter might
No.
be-
Your Lordship, here case is charged sheeted already.
Fine.
And there are two accused. But settlement is done with only one
One
accused.
is the sister. Sister, she was just an informant, that's all.
Yes.
The main assaulting is by him and his wife, younger sister, elder auntie of the petitioner. Next time you take that, please.
Obliged.
Matter might be stayed till the returnable day.
Not satisfied.
April.
Obliged.
May I please one? My lord, in this matter, we are agreed with the impugned order dated 29/2/2024,
Notices have not been issued.
not been issued, listed for first time.
Where's the impugned order?
At page 21,
21.
21,
20?
21, 2-1, my lord.
Ah. UF 40 respondents number?
12, 13, 14 and 15. Leaving aside, my lord, giving findings in the material that was available before the learned civil judge senior division, my lord. This title suit itself, my lord, ought not to have been taken up by the senior division.
Time may not be permissible today to consider. It said much facts.
My lord. In that case, my lord, tomorrow.
When was this order passed?
29/2/2024. Within limitation.
What were you doing for such a long time?
Actually, after reserving the judgment, it was pronounced that.
Okay. No, it was pronounced on 29/2 itself.
No, my lord. We obtained the certified copy only on 7/5/2024.
Where have you stated?
I have not stated it, but in the certified copy, my lord, original certified copy.
It's here on record. You have the original certified copy?
My lord,
Yes. When was it?
7/5/24, my lord.
Where do I get it here?
Down below, my lord, in the impugn order itself. Certified true copy by the Srishti there.
Now, when did you apply for this?
Applied
This is the issue. CTC issued it. When did you apply? It's not reflected here.
It is not reflected, my lord. Otherwise, my lord, what is my contention is there, my lord. Arunachal Pradesh Civil Court Act 2021, my lord.
Sir, I have only 5 minutes. I have to go into this. That's the only problem. You have not made a statement also that order dated 29/2 was only received on 7/5.
No, my lord, since this was within the limitation period, my lord.
No, that's different thing. It's
My lord.
against an interim order.
My
You
lord.
waited for 3 months literally to come up. That's why I was asking you.
Kindly, my lord, paragraph 2 may be seen,
Page?
page 8.
That is not the answer to my query. Anyway, heard Mr. You're Mr. K. Tamam, learned counsel for the petitioner. You will be praying for an interim stay of this.
My lord.
List this matter again on when? You are coming from outside when? Tuesday, Wednesday, or Monday?
Tomorrow, it is not.
Tomorrow will not be possible. I'll not be here. अर्जेंट कुछ है क्या देख लीजिए
Monday,
मंडे ये 14 का कोई नहीं मंडे 3/4 3/6
3/6 में
3/6
हाईली
बाकी कोई अर्जेंट मैटर है क्या कौन सा दे दीजिए बेल जी एनी अर्जेंट मैटर
Item number 2, my lord. This is interim order was passed on 19/3/2020.
Have you got this CD?
Yes, your lordship.
What is it?
13, item number 12.
Yes, your item number 12, we have received the case diary and
What is it?
yeah, statement, everything recorded, your
And what
lordship.
is why keep him back? Anywhere required? No required.
No custody detention is deemed required, your lordship. It's
Okay.
not required.
Heard Mr. S. Maulana. What is the issue? Upset.
Yes, my lord.
When were you arrested? 9/3.
No.
Charge sheet filed? No.
No, no, Your Lordship, his investigation is going on. Your Lordship, he is in the possession of the firearm. The old firearm is belong to his father.
Okay, okay.
So it was given
it.
for repairment.
Did I hear this matter at one point?
Yes, Your Lordship.
I got it.
It was day before yesterday. I have
I
seen
got
them. Yes.
But Mr. S. Mao, learned counsel for the applicant, and also Mr. Ete, learned additional public prosecutor, appearing for the state respondents. Mr. Ete has produced the case diary pertaining to in connection with Anini PS case number 3 of 2024, raised under section 25, bracketed 1-A of the Arms Act 1959. It is seen that the petitioner hearing, in terms of the conditions as stipulated in the interim bail as granted to him while order dated 19/3/2024, has appeared before the investigating officer.
Your Lordship, actually prior to that, his statements are recorded. 41A notice has been duly complied by him, Your Lordship. It's on recorded on.
Has submitted that the petitioner has duly complied with the section 41 notice. Oh, आगे वाला कर दीजिएगा. Section 41 notice issued to him. Full stop. On perusal of the materials available on record, it is seen that there is no further necessity. There is no necessity at this stage for a custodial interrogation of the petitioner hearing, and accordingly, the interim bail as granted to the petitioner, while the order dated 19/3/2024 is made absolute in terms thereof. Also, the conditions as laid out in the order dated 19/3/2024 shall continue to apply in the matter, and the petitioner is required to comply with the same. Full stop. With the above observations and directions, the present bail application stands disposed of.
How much?
Your Lordship, I had filed my IA, Your Lordship, for vacating of the interim order, Your Lordship. Your Lordship, in this matter, the applicant was granted interim bail on 19th of March 2024. However, till date, nor the bail application was executed, nor the applicant is.
Have you served a copy on them?
Yes, Your Lordship.
Yes, Mr. Dubey. Who is appearing? Dubey.
No, this is
next
D. Gogoi, in fact. I had also informed him telephonically yesterday itself, Your Lordship.
She has not come.
Yes, Your Lordship. We have sent the copy to the local council.
Nobody is appearing.
Nobody is represented. Even on the last occasion, Your Lordship, no one had appeared on 27th.
This item 14 is going on?
13.
Also, early come. None, Miss, the present, IAC, interlocutory application 49 EP of 2022. Miss T. Jimmy, learned counsel, Ranesh additional public prosecutor, has submitted that the present interlocutory application has been instituted, praying for vacation of the interim directions, interim bail granted by this court while order dated 19/3/2024 in AB 60/2024. It is submitted by Ms. Jenny that the petitioner hearing has not performed has violated the conditions on which the said interim bail was so granted to him in the matter. So accordingly, she prays for vacation of the said order. Also, none has entered appearance on behalf of the sole of the opposite party, of the accused opposite party. Also, accordingly, for the ends of justice, list this matter again on
Second, Your Lordship.
7/6/2024, on which date orders as may be necessary, as called for in the matter, shall be considered to be passed by this court.
Deeply.
Time is up.
Which one?
This item 21, small service matter transfer posting, if my lord can
Today.
accommodate me tomorrow.
Tomorrow I may not be here. That's a problem.
It will take 10 minutes maximum.
But I'll have to pass an order, no? That's a problem.
I'm told that already this private respondent has been already released. Released from this.
Well, he'll give a date. He'll give a date. He'll give a date. Yes, item number 14. Yes, Mr. Dubey.
My lord, kindly have a look at order dated 14/3, my lord.
That's what I was waiting for till date. Till date, they have not. Have they
My
filed an
lord.
affidavit?
No, Your
Then
Lordship.
You are protected.
Till today.
We'll extend. What to do now? He has
Yes,
not
Your
even filed an affidavit.
Yes, Your Lordship. They in fact, before the court, they have assured that they will file.
I was every day inquiring whether they will file or not, but not. Because once we have passed an order, we'll have to take that on.
Yes, Your Lordship. Absolutely, Your Lordship.
Anyway, it is seen that the affidavit as directed to be passed in the matter by the respondent number 2, while the order dated 14/3/2024 has not been filed till date. So, accordingly, as a last chance, list this matter again on when, Mr. Dubey?
My lord, this is a parted matter, my lord, subject to your lordship.
No, I cannot keep it parted. That's the problem. Because I'll be leaving. Anyway, I'll come back. It will come back to me. Don't worry. List it again on. Let us put it on 17th.
17th.
17/6/2024. Full stop. The matter be not treated as parted anymore. 17, if it goes to July, maybe in the second week I'll be here.
Okay, no issue.
My
I've gone through it.
Yes, Your Lordship.
Now,
Now,
the interim order needs to be
Interim
continued.
order passed earlier shall continue
Yes.
until further orders.
Yes, Your Lordship, the CD is with us. So CD may be
The
returned.
CD as received be returned and be again furnished on further orders being passed in the matter by this court.
Deeply obliged, deeply.
Item number 21, Lordship, that there is a interim order that may be continued.
That any जहाँ पे interim order है सब extend ना तमाम जहाँ पे interim order है सब 23.
Deeply obliged.
My lord, item number 15.
There are many shades, Mr. Kato. It's not that easy. I've been reading the law. There are shades. Okay, just give me that file. Yes.
15, 16.
Huh.
Maybe my lord fix on after 3 weeks.
There.
15, 16, 17.
Okay. On the prayer made so and so by Mr. Son, learned counsel appearing for the petitioner. List this matters after 2 weeks on a date to be fixed by the rules. If I'll be
My definition of court,
No, I'm not on that. I'm coming to that. Oh, you last hearing. Om Prakash Pandey.
my definition of the force court is given.
No, I'm not. I'm satisfied with that.
My lord.
I'm on a different footing altogether.
My lord. The commandant has the jurisdictions to the pass and order.
You have the records with you?
Yes, ma'am.
Okay. Now show me the steps that were taken before the matter was placed before the summary court.
The inquiry
Petitioner is not here.
Yes, my lordship. May I please, your lordship? I'm
Okay,
here, my
okay.
lord.
Show me the material that you were, what was there before placing it before the ITBP Act. नहीं मेरे पास था वो लेके आया नहीं मेरा रूम में
some are in Hindi language. However, everything is covered.
They'll read it.
Before the action was taken, inquiry was conducted. Charge sheet has been handed over to him, and thereafter, he has been called for the proceedings. On the very first day, he admitted. Thereafter, the punishment has been in every matter. A specific question was also given, put to him, my lord. Then he answered, my lord, affirmatively.
My lord,
Affirmative,
admission
my lord.
of guilt and pleading guilt are entirely different, my lordship. It's a judicial proceeding, my lordship. If it is summary court, my lordship.
Plague bana करते हैं, ये था ना। Plague बना ये ना।
Show me before that it was sent to the force court, summary force court. The commandant had heard him.
Madam.
There is a
My
requirement
lord,
of
the commandant himself contacted the court, my lordship.
Oh,
The commandant himself,
fine.
he held the court.
My lord, by virtue of this section 86, my lord, the commanding officer is the, my lord, the presiding
There is no
officer.
Mr. Loskar, today, unfortunately, I cannot give you time here. But yesterday I was against you, but today, right, I was doing some research. Where is the
My
charge sheet
lordship.
you obtained?
My lordship, if it is a judicial proceeding, my lordship, if it is a for summary force court, then it must be a judicial proceeding under section 118, my lordship. They cannot infer guilt, my lordship. There is a procedure in a judicial proceeding for pleading guilty, my lordship. They cannot simply infer guilty from my statement, my lordship, because it's a judicial proceeding, my lordship.
No, I've got it. Who was his next friend? Was a next friend appointed?
Appointed, my lord. And charge sheet copy was handed over to the, my lord, accused persons on 9th January 2017, my lord. And the notice was issued for his appearance, and the summary court trial was held at
It's not possible. It's already 4:23.
My lord.
So the Mr. M. Khatub, learned counsel for the deputy SGI, has produced the relevant records. However, Mr. S.B. Loskar is also present for the petitioners. However, on account of positive, however, due to positive time, the matter could not be taken up for consideration. Full stop. List this matter again on when, Mr. Loskar?
My lordship, any convenient date, my lordship, since your lordship has heard the matter.
I'll not be here for a month.
Then my lordship, it can be kept part heard at any date, my lordship, because.
Let it be on 19th. You make arrangements. I'll see. List this matter again on 19/6/2024. 2024. Next date, send this records back again to him. Anything, any more urgent matter?
Yes, my lord. My lord, this item number 22 is which tender matter.
It will not be.
Yes, it will not be possible. Lordship, can it be heard?
List this matter again on Monday?
Lordship, I was seeking for tomorrow.
Will not be possible.
Then
Monday.
Lordship, it will-
Monday.
Interim order.
Interim order to continue till the next day.
Yes, ma'am.
Interim order is passed by the, oh no.
Yes, yes. Much obliged.